Testing 1 2 3. Testing 1 2 3. Test test test. This is a test of the Seventh Circuit Court of Appeals.
United States Court of Appeals standing before the Southern Judicial Circuit. Hear ye, hear ye, hear ye. All persons having business before this honorable court are admonished to draw near and give their attention, as the court is now sitting. God save the United States and this honorable court.
Good morning, everyone. Our first case up for oral argument this morning is United States v. Quay, 24-2495. Good morning, Mr. Herman.
Good morning, and may it please the court, counsel. My name is Josh Herman, and with Susan Pavlo, we are here on behalf of defendant appellant Charles Quay. The case against Mr. Quay is another instance of the government testing and ultimately breaching the outer limits of a federal bribery statute. In this case, that statute being 18 U.S.C. 666A2. Mr. Quay was a real estate developer in Chicago who had legal problems. People with legal problems hire lawyers. Lawyers are hired to influence others. Everyone in this courtroom, standing behind me, myself included, are in the business of influencing and persuading. And as the record shows, Mr. Quay hired a lot of lawyers. The 26.1 disclosure discloses that. At the heart of the case, Mr. Quay was convicted of attempting to hire a lawyer. That lawyer happened to also be Edward Burke, sitting alderman in the city of Chicago. Quay had two legal problems. He had a property tax issue, and he had an issue with zoning, with the pole sign of this Binny's store in Irving Park. The government's smoking gun evidence, exhibits 271 and 272, these emails from Quay to Burke, there was a voicemail also, speak not to his guilt, but to his mental state, which is stating specifically he is in need of legal representation for a legal matter.
But what about the email to his current tax attorney where he says, I need his favor, referring to Mr. Burke, for my TIF money, and so I'm going to send him my property tax business?
Sure. That email, you also note in that email, he says to his lawyer, I need your favor. This is not only Mr. Quay's colloquialism and way of speaking, and a favor is not meaning... But
it's not the fact that, again, viewing the evidence in the light most favorable to the government, as we have to at this stage, it's not the fact that he needs a favor. It's the fact that he needs a favor for this TIF money and this poster, but he's going to try to get it through the tax property business.
So he needs a favor for Mr. Burke as a lawyer to take on his case. That is the favor he is seeking. And as any lawyer will know...
But that's your interpretation. I think there's... And you were free to argue that to the jury. But we are at the view the evidence in the light most favorable to the government, and that email, along with the email before that where he was saying he emailed Chin and hadn't heard back from Burke and said, oh, he's going to plan to offer him the property tax appeal work at that point. When you put that together and view it in the light most favorable to the government, I don't know how you get around that. So
the response to that, Your Honor, is I think, and this is where this case is, there are a lot of nesting dolls and overlapping issues, including with the problems with the jury instructions and the sufficiency. And our position is that there was insufficient evidence separate and apart from the flawed jury instructions that I hope to get to as well. But even seeking a favor to hire a lawyer, this isn't a situation where he is seeking a favor of somebody who is in no position, who's not wearing two hats. And I understand that from the sufficiency, from the taking the reasonable inferences in the government's favor, but this is also a situation when you take the other words that Mr. Quay said by seeking legal representation. This isn't a situation where he said, I just want him to do me a favor separate and apart from his role as a lawyer in a vacuum. This is in conjunction with acting as a lawyer. And as most lawyers know, you may not be incentivized to take a small matter, but if there's a larger matter that is offered in conjunction with that, you often take two cases on for a client, a small case. We have an example in our briefs about a criminal defense lawyer may not want to take a DUI, but if the client also offers a felony, that's the influence part. I'm sorry.
That's a really good jury argument, but it failed here. It's not a great argument on appeal, given the standard of review, as Judge St. Eve has mentioned. And there was more to the email exchange talking about Ed Burke as a powerful broker in City Hall, etc. So. But the legal issues having to do with the jury instructions are probably a better focus here.
Sure, and I'll get to that in a second. But just to diffuse a little of kind of, we say that the government uses clout pejoratively, and there's an aspect to that true. But again, individuals hire lawyers who they believe can influence others, and that is just the nature of the business. For the jury instructions, I'll turn to the jury instructions. Actually, very quickly, before turning to the jury instructions, I do want to make note that our sufficiency argument isn't simply related to this favor aspect. We do have the bona fide services, safe harbor as well. Those matters were fully briefed. In addition to that, we've also argued the gratuity aspect and the lack of an official act. So even if the court were to say the evidence is sufficient to say that there was
On the official act, though, your argument is there wasn't an official act taken here, but I think your focus is wrong. The question isn't whether or not there was an official act actually taken. It's whether your client corruptly offered something of value, intending to influence Mr. Burke to take that official act.
Well, there still would need to be, we would submit an official act at the end, and the jury was so instructed on official acts and with the McDonnell type of instruction, and there
had to be an official act for Mr. Burke.
Correct, and I think that if for here the official act, and again, this is, I'm going to move on to the jury instructions, but this also circles back to the intent of Mr. Quay to hire a lawyer to hire Burke and not to bribe Burke. But turning to the jury instructions, we have two central arguments here. The first being, and these issues were fully preserved below. I think docket 375 was trial counsel's request for these particular jury instructions, and they both focus on count 12, which is the 666A2 bribery instruction. Below, Quay sought not only a definition of the requirement of a quid pro quo with the specific language of in exchange, and that request was overruled. And in the Rule 29 motion, Chief Judge Kendall said the phraseology of in connection does the work for, or it says in so many words, the exchange. In connection and in exchange are not the same. In connection is any type of relationship that is not necessarily a transactional relationship. The in exchange language, and this is where Snyder provides guidance for us, having quid pro quo being the central aspect of any type of bribery case. That was simply not here. One can perform an official act in connection or parallel to some type of value offered, but that performance of the official act isn't done in a transactional exchange. So Quay was convicted here simply by having the offer for legal services being somewhat connected to Burke's phone calls to the two individuals in the city, not necessarily in exchange. And I'll note, and this isn't in the briefs, and my attention was just drawn to it, but this court's jury instruction committee is currently contemplating using in exchange because of a quid pro quo requirement. And in that instruction, and this goes to the intent to influence element, to be specific about it, you have an instruction that says a thing of value in exchange for an official act in connection with some business. It's the act that's in connection with the business. The value that's conferred is what's exchanged for the official act. So the instructions that were given to the jury over Quay's objection lacked what we would submit as an essential element and obviated the finding of a quid pro quo exchange, which is, of course, Snyder makes it abundantly clear, and Sun Diamond before that is at the heart of any type of bribery case. The other problem that Quay cited was the lack of a corrupt definition. And we recognize that the committee hasn't gone that far to recommend a definition of corrupt, but at some time, something needs to give with respect to that definition of corruptly.
The Supreme Court has said that bribery is inherently
Right.
corrupt. Why isn't that sufficient?
Right, because it creates a vicious circle where somebody could say it's bribery because it's corrupt, and it's corrupt because it's bribery. The definition.
Is that true, though, when you have the intent element in the instructions?
Well, that gets back to the problems work in tandem. When you have an intent element, an intent to influence element that lacks the quid pro quo exchange, and it's just a value done in connection with another official act, you're missing, you're not tying the knots together with respect to the correct mental state. And I will note, as we cited in our briefs, the Solicitor General in Snyder acknowledged that the corrupt mental state has a sense of wrongfulness. This court has said in Snyder Part 1, or the first decision, that corrupt is tantamount to knowledge that something is forbidden. On remand, when this court determined, of Snyder, when this court determined that the evidence was sufficient for the case to proceed, wrote, the evidence all support reasonable inferences that Snyder was conscious of wrongdoing and had a corrupt state of mind. Arthur Anderson talks about the corrupt mental state. So even, the government notes that there is no willfulness mental state. Corrupt is almost a term that has to be defined by something other than the name of the statute. You can't define something corrupt by saying it's a bribe. There needs to be an additional mental state, and perhaps that additional mental state can be supplied with the correct instruction on the in exchange element, because yes, a benefit conferred in connection with an official act may not be inherently corrupt, but a benefit conferred in exchange for something else would be. And I think that's where, when the Supreme Court says corrupt mental state is satisfied by bribery, it's thinking about a bribery with a quid pro quo. I noticed my time, the light hasn't gone off, but
You're in your rebuttal time,
I'm
so
in my rebuttal
we'll save
time.
that for rebuttal. Good morning, Ms. Sullivan.
May it please the court, Irene Sullivan on behalf of the United States. The evidence overwhelmingly established and the properly instructed jury correctly found that defendant offered Alderman Ed Burke a bribe. Specifically, the evidence showed that defendant offered Burke's law firm tax appeal work to influence Burke so that he would take official action to reverse the city's denial of defendant's pole sign permit application. This evidence included defendant's own words. Defendant emailed his friend Ray Chin that he offered Burke the tax appeal work as a big bite to get Burke to act regarding the pole sign matter. In another email, defendant told his existing property tax attorney that he transferred the tax appeal work to Burke for just 1 year because he needed Burke's favor for his TIF money. He said, quote, "I need his help for my zoning, etc., for my project. I need him now." And there's also the timing. Burke personally contacted City Department of Buildings Commissioner Judy Friedland and Zoning Administrator Patricia Scudiero only after receiving defendant's offer. In short, the evidence demonstrated that defendant offered tax work to Burke, a quid, in exchange for Burke taking official action with respect to defendant's pole sign, a quo. This was a clear-cut bribe, not in the usual course of business. The evidence also showed that defendant acted with the intent that Burke would take official action on the pole sign matter. The evidence showed that he intended for Burke to use his official position to reverse a decision made by the city.
Ms. Sullivan, I want to turn to the jury instructions, please. The quid pro quo argument, is it the government's argument that quid pro quo is not necessary after Snyder, or that the current language of the jury instructions address the quid pro quo with the in connection with language, or both?
The government's position, Your Honor, is not that the jury instructions would be sufficient in every case, but in this case, on these facts, where defendant offered Burke tax appeal work in exchange for Burke taking action, official action regarding the pole sign matter, in connection could only mean here in exchange for. Again, in this context, as I just explained.
So the instructions are error in general, but not as applied in this case?
Your Honor, in considering both the Supreme Court's decision in Snyder and the Seventh Circuit's opinion on remand from Snyder, I think that the Seventh Circuit opinion on remand makes clear that when there are facts that could be construed as a gratuity, that the jury instructions as offered are insufficient. There is no evidence of a gratuity in this case. In this case, as I just said, in connection with could only mean in exchange for. That's what the evidence showed. That's how it was argued to the jury. And
was that the defense, that this was just a gratuity, or was the defense that this was the tax appeal work was just completely unrelated to the request for zoning assistance?
The defense in large part, Your Honor, was that the defense in large part was that this was a ordinary offer of an ordinary request for legal services, as counsel explained in detail in his colloquy with you, Your Honor.
So it was the case was neither prosecuted nor defended as a gratuities case. Gratuities just dropped out after the Snyder decision came down in the middle of the proceeding.
This case was never argued to the jury as a gratuities case. The jury was not aware that there was a potential of a gratuities angle in this case. And these
by either side, correct? So I know the government, and there was a lot of discussion around the jury instructions and during the course of the trial about bribery versus gratuity. And the government said, although the evidence would support both, you were pursuing a bribery theory.
Yes, that's right.
Was the defense didn't argue that to follow up on Judge Sykes' question, that it was a gratuity, not a bribery, correct? They said it was legitimate legal work.
That is correct, Your Honor. The defense never argued that this was a gratuity here. In fact, they argued at several points in the district court that there was not evidence supporting a gratuity here either. And during the jury instructions conference, also at several points in post-trial motions. But the short of it is also that these instructions map, the instructions that were given here map this statute exactly. And in Snyder, the Supreme Court did not say that, they did not invalidate or even discuss the meaning of in connection with. So in a case where the facts support a bribe, it was argued to the jury as a bribe. There's no evidence that could support a possible gratuity theory. Our position is that these instructions are sufficient. Turning to corruptly, Snyder did not disturb circuit precedent defining the term corruptly in a case with these facts. Indeed, as Judge St. Eve has already noted, Snyder announced that bribes are inherently corrupt, signaling that no further definition is necessary in a case where the evidence only showed a bribe. For these reasons, the jury was properly instructed, and even if not, any error was harmless. The government's evidence showed defendant offered legal work in exchange for Burke taking official action on the pole sign matter. Simply put, a bribe. Defendant's own emails, plus his lies to the FBI, showed that he knew that his conduct was forbidden. Indeed, the evidence showed defendant knew that he engaged in a this for that exchange. If there are no further questions, the government asks this court to affirm defendant's conviction and sentence.
I have a question about the photoshopped image. In the order on the motion in limine, I didn't see a lot of balancing when the judge got to the 403 issue. If we were to find that it was error to admit that email, does it matter? Was it harmless?
Your Honor, for the many reasons already explained, there was ample evidence to support that there was a bribe here, independent of the Photoshop image. But in terms of the Rule 403 analysis, intent was the key issue at trial, and this photo showed defendant's willingness to take shortcuts. It showed his state of mind during the very window of time in which he sought Burke's help.
I understand the state of mind point, and I actually agree it does show state of mind. But I guess my concern is that there's a very strong propensity inference here. You just said it. The judge said it. He took shortcuts. He's a cheater. Of course, he bribed someone, right? So I didn't see any consideration, or it's very flimsy in the district court's order.
First, Your Honor, as the district court found as well, I think the district court acted well within its discretion to admit this as direct evidence, since it goes to defendant's intent. This is a photo of the pole sign at the very heart of the bribery scheme, and in terms of the non-propensity chain of reasoning, this clearly showed the importance that defendant placed on reversing the denial of the pole sign permit. The photo was submitted to the Department of Buildings immediately after Burke had put the Department of Buildings Commissioner Friedland on notice that this was coming down the pike. And with that setup, defendant then took his opportunity to submit this photo to provide the basis for which the Department of Buildings would be able to potentially reverse the decision that the commission had previously made.
Is that argument, Ms. Sullivan, that you just made about the importance, is that an argument that this is direct evidence, or is that an argument in favor of the 404B, or both?
And when you say about the importance, could you?
You just told us that this pole sign image, photoshopped image, showed the importance that Mr. Quay placed on getting this done. Are you making that argument that the pole sign, the photoshopped pole sign, is direct evidence, or does that argument go to the 404B intent piece?
I believe it does go to both, Your Honor. I think it shows defendant's intent to bribe Burke to effectuate the reversal of the pole sign permit at the exact same time that this was all ongoing. This happened all in the very same week. But it also then, of course, shows his intent and state of mind under 404B. And again, if there are no further questions, I ask this court to affirm.
Thank you. Mr. Herman, you have a little bit of rebuttal time left.
Thank you, Judge. Briefly on the instructions. We'll note that at footnote 2 of our principal brief, almost contemporaneously with Mr. Quay being tried, the government in several other bribery cases is including not only a definition of in exchange and a definition of corruptly. And I think it's highly significant that that was omitted here. And I think it's noteworthy that those are required elements, and the government knows it. And with regard to Judge Maldonado and the follow-up questions on the poll sign, this can't be direct evidence. We pointed out in the brief how Mr. Burke sought a limiting instruction on the evidence of the poll sign being, the Photoshop being used against him, and the judge gave it. It's not direct evidence of the bribery of Burke. It, in fact, undermined the bribery of Burke. In the second calls with the zoning official, she after it was noted that there
But it
was...
could be direct evidence to Quay and not to Burke, correct?
Well, the direct evidence of a, and this would go more to the 404B mental state issue, I don't think that there was any doubt that Quay wanted this poll sign. This wasn't a situation where the defense at trial was, I didn't care about it, and then you would bring in evidence of him doctoring a photo or allegedly doctoring a photo that would show that, no, you actually cared about it. That wasn't to rebut any defense at trial. And in terms of the 403 analysis, he was also charged with the 1001, which is lying to federal agents. It was extremely prejudicial to have evidence of him using a lawyer to submit a Photoshop sign to government officials when at the same time he's being tried of lying to government officials. If there are no other further questions, we would ask that the court reverse Mr. Quay's convictions, order a new trial, and/or order a resentencing based on the brief submitted. Thank you.
Thank you, Mr. Herman. Thank you, Ms. Sullivan. The court will take the case under advisement. The next case for argument this morning is Gibson versus Chubb National Insurance Company, case number 25-1121. Good morning.
Good morning, Your Honor. Good morning, counsel, Your Honors. David Goodman on behalf of Wesley Gibson along with Adrian Mendoza. May it please the court. In the 10 years preceding the fire in October 2019, Mr. Gibson bought a policy of insurance from Chubb for his home, for his vacation home. Year after year, each year, the policy had began with a summary of the policy with description of what's covered, including the contents, with $3.5 million of coverage, the dwelling, $8.7 million of coverage. It identified the valuable articles coverage. It talked about the liability coverage. There was not a word within that at all to describe or discuss business property. It wasn't a surprise to Chubb when it was writing this policy that Mr. Gibson was using the house for both personal and business use. The underwriters who wrote the policy were aware of this. They noted that this is a client who has a location called Pine Manor. When it was originally presented to us, this is in 2017. It was for use with his clients. He has his own firm, Gibson Consulting, sold his first consulting firm back in 2001. They come up to the property, and he has space for a lot of folks for retreats, etc. They wrote insurance policies actually not just for Pine Manor, but for I believe the other 8 houses that were, in the area and the environs. In this case, though, when the court looked at the contents claim, it made an error of law in its construction of the insurance policy. It failed to follow Illinois law relating to the construction of the policy, and in particular in its reading of the business property exclusion and its very, very broad reading of the exclusion. Here the contents coverage defines the scope of coverage that at issue. And it's very clear as to what is covered. It's personal property that's owned or possessed by the insured or his family members. It focuses on ownership, not use. And it goes further. It says literally anywhere in the world. So it's not defined by where it's found. It's defined by ownership.
But the business exclusion focuses on use.
Well,
and
actually,
is pretty plainly applicable here, given the evidence of the use of this property as a luxury B&B.
the business exclusion itself just says business property. It doesn't identify what business property is, doesn't talk about use at all. It just says
Used to conduct your business.
the business property exclusion doesn't actually say that.
Well, that's how business property is defined.
They're actually, you're talking about is the definition of business property in the extra coverage, in the extra coverage, not in the exclusion.
Well, but the exclusion says policy that coverage is excluded for any loss to business property.
It says we do not cover any loss to business property other than is provided under extra coverages. That's
Right.
what it says.
Then that loops in the definition, the broad definition of business policy or business property, and then the $25,000 limitation on that exclusion. In other words, there's a restoration of coverage for business property, but only to the extent of $25,000.
There's actually, so there's the exclusion itself, and then there is something in addition. There's a grant of coverage, that's the extra coverage, and then there's the exclusion, which is a narrowing of the contents coverage. And it's not, and so what does it mean? And it doesn't identify the use, it doesn't limit the use. I mean, there is, you're correct. If I look at the definition of what constitutes business property under the extra coverage, it talks about business property you own or possess. What is business property? And, I mean, one of the questions I have is what is business property? And it identifies, it says business property means furniture, supplies, equipment, inventory, semicolon. Books, records, and, semicolon, and electronic data processing property used to conduct your business. So does the use to conduct your business modify just the electronic data processing? I don't know. I mean, I'm not a grammarian, and honestly, this doesn't read really well. It certainly could have been written more cleanly, more clearly, if what they were trying to do was call out, no matter how you use your property, if you use it at all, if you use it incidentally, if I were to pull out my cell phone on the bus and look at it and an email, that would be an occasional email from work. That would be an occasional use, even though I own my phone and I use it every single day. It would be if I used my, as I do actually, my dining room table at home when I work from home, when I look at night at briefs, when I write things at home, my dining room table has then been transformed into business property because that's where I conduct work each night. So is that what it means? Is that what an ordinary, reasonable person...
Right, but this case doesn't involve those kinds of examples that are at the margins. This property is being used for most of the year for business purposes as a bed and breakfast and events and conference facility. The family only used it for 70 days a year for personal use.
Well, the property itself, what is the property, and how he built this house, brought his personal property into this house.
Well, that's how it started out, and perhaps when the policy was originally written, that's the information he provided to the insurer, and the insurer only discovered belatedly through an online search that this was actually being used as a B&B.
It was actually never used as a B&B.
Well, not being, but I'm using that term colloquially. It's an events facility and conference facility and...
But they knew that. Chubb knew that from the beginning. The use that you're talking about, the substantial use of the house. And
But it's not Chubb's obligation to determine your coverage that you want. In fact, there's evidence that your client was advised through Chubb, through the agent, that this may not be the right property insurance for him.
It's Chubb's obligation to be clear in defining what the exclusion applies to and what it doesn't. And here, where from the beginning of the time that Chubb sold him this policy, it understood how he was using this property. And it was, and
Are you arguing that business property under exclusions means something different than business property under extra coverage?
I'm saying it's not clear. I'm saying that business property under the exclusions, if you look at the beginning of the policy where they describe how I'm supposed to understand the terms, business property is not capitalized, it's not called out, it's not defined.
It's only defined under extra coverage, so why wouldn't the same definition apply?
It's defined in the context of a grant of coverage, where the burden would be on Mr. Gibson to establish that the property in fact qualifies as business property. The burden
For purposes of claiming the $25,000
Correct.
policy limits.
That's right. The burden in terms of the applying the exclusion isn't his, it's Chubb's. And it's Chubb's burden to be clear about what is business property for the purposes of the exclusion. And I'll tell you, if you look at how they describe and discuss other exclusions, for example, golf carts, they're exhaustive. They're very, very clear. On this one, they're not. And so in a time, in a world in which people use property for mixed use all the time, how much use? I mean, you're correct, Judge Sykes. I mean, he did use the property for. I'm not disputing that he used the record established uses the property a lot for business. He also used it a lot for personal, and it's his personal property. So at a minimum, the fact that it's in his house doesn't transform everything to business property. You'd have to look at and evaluate and understand how it was used. In this case, the court didn't do that. The court sort of weighed evidence and said, well, this is what I find, but it didn't actually, it was weighing evidence. There were disputes of fact.
But that's not what the court did. The court found that the facility was primarily used for business, and because of that, anything within it was business property.
Yeah, but that isn't how the contents coverage is defined. It's not defined by where it's found. It's specifically not defined by where it's found. It's defined by ownership. And so the fact that it's in a facility that's used in this manner, I mean, in fact, to reach her conclusion, she had to add language. She had to say, I'm going to, we'll carve out the property that you keep under lock and key. That's, of course, nowhere in the policy as well. So to get to her conclusion, she couldn't use the policy as written. She had to read it a different way. She had to add language that wasn't found within the policy itself.
Well, the policy as written cross-references the extra coverages provisions regarding business use and the definition of business property.
It doesn't talk about the definition, doesn't identify where to find it, but it does say extra coverages. It specifically
Right. It says go there to find the definition, not the definitions of these terms, but it incorporates through that cross-reference the language of the extra coverages provision.
And even there, does it actually mean that it depends, how much, if you use it at all? Does it make any sort of qualitative, delineation or
Well, we don't have a margins case here, so the dispute about whether it says whether you use it at all or incidentally doesn't really matter here.
Which piece of property are we talking about? That's the other piece. When the court looked at this, she said, because everything's in this house, and this house is used a lot, predominantly. She even said, well, I think it's dubious because how it is tax return. I mean, again, I think that that's a case where the court is going and doing what it's not supposed to be doing on a summary judgment. That would be a function for a jury to be weighing the evidence and understanding the use. So, if I may, I know I've got 3
Yes,
minutes
you
left.
can save your time for rebuttal.
Thank you so much.
Thank you. Mr. Hacker?
Good morning, Your Honors. May it please the Court. John Hacker for Appellee Chubb. After fire destroyed the Pine Manor facility in 2019, Chubb promptly paid almost $9 million for the value of the dwelling, but the policy, as has been discussed this morning, provided only $25,000 for the contents used as business property, and because the facility and its contents were being used predominantly as a commercial hospitality facility, Chubb agreed to pay that $25,000 business property limit for the lost contents, with some exceptions for property locked away and some valuable articles. That coverage determination did not breach the policy. There was no vexatious or unreasonable claims handling under Illinois Insurance Code Section 155, and Mr. Gibson has no cognizable claim under the Illinois Consumer Fraud Act, ICFA, independent of his failed Section 155 claim. With respect, Your Honors, the judgment should be affirmed. As I think we've heard already this morning, the operative question here is really whether Chubb erred in determining that Pine Manor's contents constituted business property within the policy based on the predominant use of the facility as a commercial hospitality venture. And as Judge Bucklow recognized, it's quite a simple point. In this commercial hospitality business, all of the contents were used to conduct that business. Otherwise, in a hospitality space like this, the walls would be incredibly barren and unappealing, which would be terrible to attract and retain guests of the hospitality business.
Mr. Hacker, the policy here has exclusions, and it excludes business property. And it does not define what that business property is under the exclusions. There's an exception under extra coverages. And if you go to extra coverages, business property is defined there. What is Chubb's position about the meaning of business property under exclusions? Is it the same as under extra coverage, or is it something different?
I think it is the same, and with respect, I think the exclusion actually does define business property by cross-reference, I think was the phrase that Judge Sykes used. It's not written there literally like on ink and paper right there, but it says it excludes business property, I think, except as otherwise provided. And then that's what the extra, so that's a direct reference. Just you look around the policy and see if business property is otherwise provided. Extra expense,
So if
answers
that's
that and defines it.
If that's the case, under extra coverage, business property gives specific categories: furniture, supplies, equipment, inventory, books, records, etc. Why wouldn't it have been proper to go through the extensive inventory and just to make sure that the items fall within there? Because there seem to be some things in the inventory that don't necessarily fall within any of those categories.
Right, so a couple of points, or maybe one point, a couple sub-points, which is the way the adjusters conducted the investigation was to determine, first of all, there's a total loss, and then to determine what the facility was doing, what the facility was being used for, which could be different kinds of business. Part of it could be used for business. Those kinds of inquiries might be relevant if, like, there's one room is being used to make and sell arts or crafts.
Right.
Here, the entire facility is being used to conduct the business, and so that was the threshold determination. And then, and this may be the critical answer to your question, the adjusters gave Mr. Gibson multiple opportunities to explain, show us things within the facility that were not used to conduct that business, because
But
know
is
the
that
facts.
the question? Or is the question, show us things that were not furniture, supplies, equipment, inventory, books, records?
Used to conduct your business. I think that's the relevant point. Those are all.
But it sounds like you're saying anything that was in there that was used to conduct the business should be covered. Wouldn't it only be anything that falls within these categories used to conduct the business? So in other words, furniture, supplies, equipment. If you have items that fall outside of those categories, even if they're used to conduct the business, why would they be business property if that's how you're defining business property?
Right, so here it's two related answers, I think, which is that is the kind of opportunity that we gave Mr. Gibson to provide information, but also in a hospitality business like this, I do think you're not starting off by parsing things that way. I think anything that is available to be used by guests and not locked away, and that's where we ended up. Right, he did establish ultimately that certain things were locked away, not available to be used by guests. Those weren't covered precisely because they weren't.
But
Anything
that's not
else,
tied to the definition.
with respect, I think it is, because in this hospitality business, anything that's available to the guests is supplies, equipment, inventory used to conduct the business. There are things that make it attractive and appealing. If he wanted to show that there were certain items that, even though they were available to be used by any guest, somehow weren't used in the business, that was that opportunity was given to him.
Would that fall on him, or would that fall on Chubb to establish it falls within the exclusion to begin with?
I think there's two separate questions. In the adjustment process, everybody's just trying to gather facts, right? There's no burden shifting, it's not, we're talking about, it's just like,
Right.
We've determined that this facility is a commercial hospitality facility. Everything available to the guests appears to us to be used in that to attract and retain guests. Give us facts that show otherwise. He didn't provide any of those facts. That's a different question then when you come to court. What's the record that's been developed in the claims adjustment process where the facts have been developed? And what Chubb established was that the entire facility was used as a commercial hospitality facility, the contents were used, and he didn't adduce any evidence to show otherwise, right? There wasn't any basis for that. His argument was a different one. His argument was, as you heard a version of this morning, the whole place, it was a categorical argument. The whole place was our home. It was used for personal reasons, and for that reason, it can't qualify as business property because it's, I purchased it for, our family's own enjoyment.
Both sides seem to be arguing all or nothing. It does seem, looking at that inventory, that there are items on there, decorative faux flowers, framed personal photos, that wouldn't necessarily fall with any of the categories listed in the business property. I know that argument wasn't made.
Yeah, that's absolutely.
I know that argument wasn't made,
Yeah,
but
I think the answer would have been, because I do think if it had been made, the answer would have been in a commercial hospitality venue like this, faux flowers, when you go into a Hilton Garden Inn, there's faux flowers sitting there to make the place look attractive. There are photos, from the guest's perspective, the attractive photos make the place appealing. It doesn't matter to the guest that they're personal family photos. They're what, again, makes the surroundings a place the guest wants to pay money to attend. So they're being
These
used.
are the supplies.
These are the supplies, the inventory, the equipment.
Of this kind of
It feels
business.
odd to call, flowers and a picture equipment, but in a hotel, that's what, the equipment is. That's what you're using to conduct the commercial hospitality business. Let me just mention some of the key facts that haven't gone mentioned this morning. I think your honors are aware of them, but the judge relied on, none of this is disputed, to establish the underlying commercial use of the facility throughout the year. We know Gibson Consulting paid $70,000 per month to reserve the compound, including Pine Manor, for training sessions, to keep it available for rental, even if it wasn't rented every single day. No rental facility is always occupied. Very importantly, reported 365 days of business use to the IRS, had a full-time on-site property manager, 8 to 10 staff, had a commercial B&B license, a liquor license, had a CGL policy. As we know, dozens of weeks of conferences, trainings, and weddings, and a website that advertised.
Mr. Hacker, other than the
appeal.
items that were locked away, what would the $3.5 million in coverage have covered in this property?
So again, two answers. First is at the before we knew, sort of in the veil of ignorance, before the fire happens and you try to figure it out, the underwriters wouldn't know what he had locked away. So there could very well be $3.5 million of items locked away, but they don't know that. And then the second point is, as your honors pointed out, the underwriters understood by 2017 that there might be a coverage gap, that it might be that he didn't have a substantial contents coverage because this was a commercial facility as to which the contents would be business property, not housing. Said to him, explicitly said to his broker, you should look at another policy, or another getting commercial
Commercial
coverage.
property coverage.
Commercial property.
There's evidence that he had commercial CGL policy.
He got CGL. He had gotten, I think, at that point already a CGL policy.
With Chubb?
recognizing. I don't know the answer to that. Doesn't matter. I don't know if it was Chubb, but he did have a CGL policy and other indicia of running a business that you need to have to run a business, which is what was going on here. He didn't get the commercial property coverage that Chubb recommended, and as your honors have already pointed out, that's not Chubb's responsibility to ensure, we're a good business trying to recommend to a client to be sure that his coverage matches his needs. But the law says, this court says in Stone Container and in Plum, and the Illinois Appellate Court said in Nielsen, that an insurer has no duty to, ensure that the that the client, that the policyholder has exactly the right coverage. And here again, Chubb actually recommended that he get it, and for reasons that were up to him, he chose not to get that additional coverage.
Counsel, I want to go back to something that Judge St. Eve was asking about. It seems to me if we buy Chubb's definition of business property, and then you have valuable articles that are enumerated, that there's still a sliver of property, personal property, that was not paid out under the policy. I'm thinking about sentimental items, the Ronald Reagan letter, things of that sort. I don't know how much that was valued, but is it your contention that that was on Mr. Gibson to put forth? I mean, I've seen the list of inventory. I mean, it's clear that there's not complete, if you know what I mean.
I think I know
Yeah.
what I mean. I think my answer is the same as I was giving Judge St. Eve, which is, first of all, they weren't arguing. That's not the way they argued this below, that the problem here was a failure to cover the Ronald Reagan letter, and I think there's a reference to socks at some point in their brief. The problem that they were alleging was that the entire place was a home that they were using as a home, and it couldn't be. And you heard again a version of this argument that they were, they professed confusion about the exclusion not actually applying because business property, maybe the business property definition didn't apply at all to this. They were making this categorical argument that because of that, the home and all of its contents were personal property, not business property at all, right? So there wasn't that narrow article by article kind of showing. But second, had there been, again, I think anything that's available to be enjoyed by, to impress clients, patrons of a hospitality facility are being used in the conduct of the hospitality facility, even if they have sentimental value. I don't doubt that they do. But that's sentimental to the owner. It's the owner's choice to make those, to display those, to attract, retain, and impress paying clients. When they do that, they're using it to conduct their business, again, even though it has separate personal value to them. If there are no further questions, Your Honors, we would ask the court to affirm. Thank you.
Mr. Goodman, rebuttal.
We heard the beginning, again, using the phrase predominant use. I mean, again, we're adding language to a policy to narrow the scope of what's covered that isn't found in the policy and that's misleading. And there's the issue of what's locked away. You asked questions, Judge St. Eve, about things and Judge Maldonado about things that might be window dressing, sentimental things, the Ronald Reagan letter, family photos, and so forth. I mean, by their argument, they're also talking about things that are expressly covered, like the valuable articles, like the paintings, like the valuable posters, the things that are expressly covered that are not defined as business property. They would, by their argument, bring everything in the house into the business property exclusion without providing any guidance at all in the exclusion itself and in terms of how it should be interpreted. In terms of their investigation, they denied the claim in fewer than 30 days. They came out, they said, this house is used for business purposes. We have to pay for the dwelling because there isn't an exclusion, but we're going to exclude the rest. And they conducted no further investigation. Even when we submitted additional information, it was a large loss. It takes a long time to go through a large house with lots of contents. They were aware, for example, the initial adjuster who came out was aware that there were things like antiques because Mr. Gibson asked if he could remove them to try to preserve them. And the adjuster said, sure, go ahead. But they made no attempt to investigate, to evaluate, to understand what, if anything, within the house what was used for, how it was used. They just made the determination that the house is a business because it's used, in their view, predominantly for business purposes, even though it's used also for personal purposes. And thus, everything within it is inherently transformed. The locked away is something that Judge Bucklow added because apparently she was trying to, I don't really know why she added it, frankly, because it's something, the language of the policy is what it is. It should have been drafted in a way that's more careful and more direct, and that would give guidance to the ordinary person about what the scope and limitations of the coverage was, but they didn't. They sold them year after year this policy with $3.5 million of coverage, fully aware that he was using this property both for a mixed use, for an event where he was doing training to these other houses. He had a center within there where he would do the trainings. The property within that building, for example, would clearly be business property. It was used exclusively for business, for no other purpose. But how is an ordinary guy, and that's how Illinois law looks at it, how would an ordinary person understand what business property is if he's using the property for mixed use? Thus, for the reasons we've articulated in our briefs, we ask that the court be reversed, that the matter be remanded for further proceedings, because among other things, you have to evaluate what the contents actually are. And are there things that are used narrowly for business purposes? Are there things that are used for personal use? And perhaps what do we do with mixed use? Again, the exclusion itself is silent.
Thank you, Mr. Goodman. Thank you, Mr. Hacker. The court will take the case under advisement. The next case for oral argument this morning is 25-1691, U.S. versus Pena. Good morning, Mr. Hillis.
Good morning, Judge St. Eve, Judge Maldonado, Judge Sykes. My name is Daniel Hillis. I'm with the Federal Public Defender's Office. I represent Mr. Pena on this appeal. There are 4 issues. The 4th is uncontested by the government. That's the condition of supervised release about the risk to third parties, so I don't plan to spend any time on it. I'm going to focus my attention instead to start on
Actually, before you do, please, do you agree that the proper remedy for that is to remand to the district court to address it?
Oh, yes.
Okay.
And on the due process issue, we'd like a reversal. We'd like to send this case back and start with the proper procedural protections to ensure that my client has the protections that are granted to him by the Constitution, as well as 32.1 and the related case law. So with regard to the due process, my client was given materials from the probation office that were relied upon by the district court, and he received those beginning, I think, on April 9th. He received another series of police reports, or another police report on April 10th. The revocation hearing was April 16th. So he had very few days, for purposes of notice, to receive the materials that were ultimately relied upon by the district court. The government says you do not get due process. We disagree. The Constitution says that you get it. And so
But he was very clear through his lawyer that he didn't want more time. He was ready to go forward with this. So I think the notice question, and your argument that he didn't have enough time to review all of this, is hard to make, given that the court said you need more time and he wanted to go.
Grade C violations. He was ready to go on the grade Cs, not the grade Bs. And so the police reports are related to the grade B violations, and the parties agreed that that was unproven conduct. And so I would have to respectfully disagree, Your Honor, that he says that he's ready to go
But
on what?
The comments the court made with respect to the police report didn't deal with the underlying criminal activity that took place in the grade B violations. The court referenced the scuffle and the fact that he fell through the ceiling in connection with her comment that she was worried about his behavior and that he was a danger to the community, and the fact that he's not reporting to his probation officer, he's left the jurisdiction. Those grade C violations all raised her concerns that, in his criminal history, that he was a danger to the community.
I don't think they could narrow it like that. So the allegation was that he was in the Dunkin' Donuts and he was in the other place, the antique store, as a result of a burglary. So to say that it's
the court didn't say anything about the burglary. The focus from the police report was her comment about, I'm worried somebody's going to get hurt here. And in fact, what just happened with you falling through the ceiling of the bathroom onto the officer who got hurt, he says, oh yeah, I got hurt. And she said, well, that's my point.
Sure. But again, you can't take it out of the context that it was offered. It was a police report summarizing what was
I'm
alleged
reading
burglary.
from, I'm paraphrasing from the transcript. That's the context it was offered in.
No, the police officer's statement, I'm trying to focus my attention there, Judge, was about suspected burglary.
I'm
So-
focusing, and I'm sorry to interrupt, but I'm focusing on the court's use of what was in the police report, because I don't think you could say she used the whole thing. I mean, what she refers to from the police report is, again, the scuffle in the bathroom, when she's talking about, given these grade C violations in his criminal history, I'm worried somebody's gonna get hurt.
Your Honor, I again have to respectfully disagree. The police report, you can't say that the judge didn't rely on the context of where the conduct occurred and how inherently dangerous burglaries
There's
are.
nothing in what she said in the court that refers, when she's talking about the sentence, that refers to the underlying robbery there. It's
It
all
doesn't-
focused on the, somebody's gonna get hurt.
Right, and I think burglaries are inherently dangerous. That's been the law, and I don't think there's anything to the counterpoint, Judge, that the judge cabined her remarks to say, I'm not considering it as if a burglary happened here. I'm just talking about your dangerousness. And I'd put in further context, the concerns were that he's been engaged in burglaries in the past and now, or in criminal conduct related to theft of property, and he's continuing to do it in the particular context would matter, I think, to any judge. But I'll move on. So in terms of Rule 32.1 errors, the materials are nevertheless submissions by an adverse party, the police officers, and so 32.1b2c requires that the individual who was at the defense table be entitled to cross-examine, question the officers about the reports. That didn't happen. And it was also assumed that the reports were reliable, and I think both of those things are contrary to the law, especially as this court's Jordan opinion discusses the importance of honoring Rule 32.1b2c and ensuring that judges go through the necessary steps of ensuring that an individual has the opportunity
So,
to
Mr.
cross.
Hillis, if we think that the court only relied on the fact that the police officer got hurt and your client's statement that he got hurt too in the incident, do these arguments about cross-examination still apply? Or would you agree that if it is that narrow, that those don't apply?
No, the reports trigger the right, like it would the due process in the 32.1. We don't get to say now, because we think that maybe the judge was talking about something else or being very specific and narrow. The reports are the evidence that the government used, or rather the probation office used and attached to the reports. So that triggers the rights.
And when you said, when you started out that you're asking us to reverse, you're just focusing on the sentence here, not the revocation, correct?
Yes, well, there's a component of the breach that could cause us to worry about the entirety of this, but we are
Well,
focused
given your
because of
client's
election of remedy.
admissions to the grade C violations, I think
That's
you'd
right.
have a hard time asking for reversal of the revocation.
Sure, I think that we could have, but our focus is just to get the benefit of the bargain, Judge. And so when the government goes in with an agreed sentence for 14 months, we expect, in the language that is Chavez, for the government to turn square corners. And if the government is going to do things like say to the judge 14 months, but you can go higher. I mean, the purpose of alerting the judge the ability to go higher is to induce the judge to go higher and give a sentence
But
not
the judge
one
already
that-
knows that, right?
So why say it?
Well, you know, she's stating the obvious, a
She's,
statement of the law. So you think that that is the breach, that you could go higher?
two.
Okay.
So that's not unimportant, and the Diaz-Jimenez case talks about telling judges how we wouldn't be disappointed prosecutors if you give higher sentences than we ask for. Lip service, right? Turning square corners, scrupulously honoring agreements, right? The
How
government's
is that
obligation,
any
Santabella.
different than a plea agreement, where there's an agreed sentence that government agrees, I'm gonna jointly recommend X amount, but the plea agreement has a provision in it that says the court could go higher? How is that any different?
Because the judge doing it on the judge's own versus at the slight invitation of a prosecutor who, if I may further answer Judge Maldonado's question, the more glaring part of the breach, in our opinion, we don't think that the first part's unimportant. But the second part, where you're telling the judge, please consider the probation officer's presentation for a 24-month sentence, even though we've just agreed to 14, is definitely, in our view, working around the ends. And so if you're going to make an
Where do we
agreement,
draw
live
that
with
line,
it.
though? Because that's not exactly what she said. I think she said something to the extent of, I understand why probation is recommending 24 months because he's over 40 and he's been at this for a long time. So
Sure.
where do we draw that line? Because she's expressing understanding of probation's position, but she's still saying, I recommend 14 months.
Sure. Who's the captain of the ship in that circumstance? I would say it's the prosecutor. If the prosecutor says, we've agreed to 14 months, and we know sometimes that a victim may want a higher sentence or a police officer may want a higher sentence, we nevertheless leave it to the government to make the decisions about what is the appropriate sentence. And there's a reason for that, but because it falls on the exercise of their discretion and judgment. But also, we don't allow the victims and the police officers to come in and do an end run. And if the government isn't comfortable with this, there's a very, very easy way around all this so it doesn't create any problems. Don't reach agreements. Don't enter into them, right? Then we don't have this problem. Then probation can stand up and say whatever it wants, and if we make an argument about surrogate prosecution, at least it's not with the blessing of the government who just said, we agree to 14 months, but now we'd like you to entertain this presentation by the probation office for 24 months. That doesn't sound like my client's getting the benefit of the bargain.
But the government went on to say, essentially to tell the court, I understand the probation office is asking or recommending more, but we have an agreement for 14 months, and I think that is appropriate for the following reasons. You've got that but in there from the government.
Judge, there can be lots of buts, but there should also be moments where prosecutors say, we have made an agreement, Judge. We don't need to hear from the probation office. We are doing our duty. The probation officer has already done its duty. So we don't allow police officers to say,
So you're saying that the probation officer wouldn't have the right to give her opinion at that point, or to give her recommendation? That's part of the sentencing
I
process.
think it's an end run around the agreement, Judge, when you're going to bless the probation officer's efforts as the prosecutor in the
I think
revocation.
it's the blessing part that I take controversy with.
Okay, well, I don't recall anywhere in the transcript where the government opposed it and said, based on the agreement, which we are going to scrupulously honor here,
Well, the
Judge.
government did oppose it because the government said, but we recommend 14 months, and here's why.
The government explicitly asked that the judge be allowed to consider what the probation officer's presentation was. There's no two ways about that from the transcript, because the defense attorney stood, or sat, whichever, but said that this is in violation. This is surrogate prosecution, and so that is contrary to Smith and any of the good language from Peterson for us on that. Apart from the Rule 32.1 issues, and we think that it's clearly the case that when the judge relies on those ultimately at appendix pages 41 through 44 to impose sentence, we know that the dangerousness, et cetera, that is referred to, or the conduct about interactions with the police officers, however they occurred, that is influencing the sentencing decision. And so that is clearly connected. But the Asteris error, to return briefly to that, the district court is not allowed to consider the seriousness of the offense. And so this is Rule 3553A2A that allows a judge to consider that at the time of the criminal sentencing, but
The prohibition is against considering the seriousness of the underlying offense, not the violations conduct. And wasn't the judge referring to the violations conduct?
I think it's murky from the Supreme Court's decision about that, Judge, but I think the judge considered both.
Well, that's how the statute reads, I think.
As I recall the opinion.
Right, because it's referring back to the factors in 3553A, which are the sentencing factors at the original sentencing. So it has to be referring to the original underlying offense rather than the violations conduct.
Accepting that most limited reading of it, we would still have the judge saying your history of dangerousness is basically was referred to the broad, the criminal conduct that talks about his dangerousness in the prior robberies. I think that the judge is throwing her arms around not just the instant conduct, but his history, which would bring in the 3553A2A prohibition.
But doesn't that also go to deterrence?
So if it goes to both, I would say we're still covered.
The court made very clear here, the court was considering it for deterrence. And the Supreme Court said that was appropriate in Estera.
The Supreme Court, though, has also said in Asteris that you're not allowed to consider the seriousness of it. Seriousness and dangerousness are synonyms, and I don't know that we can say without effectively undermining, as Seventh Circuit's view of Asteris, what Asteris holds, that we would allow the judges to start consider dangerousness, seriousness, etc., and say that's okay because we have a slightly different read than what the express language is out of Asteris. With that, I reserve the balance of my time.
Thank you, Mr. Hillis. Ms. Mecklenburg, good morning.
May it please the court, Sherry Mecklenburg on behalf of the United States. The district court did not err in revoking defendant's supervised release, and it sounded like the appellant is no longer arguing that there was any error in the actual revocation, given that the defendant admitted violations 2 through 5, and that is what the district court based the revocation on. So I will move on to the other issues, starting with whether the government adhered to the agreement that the government made to recommend 14 months. And the court correctly recognizes that the government did adhere to that in terms of, by talking about the aggravating factors that probation based their recommendation on, what the government is signaling to the court is, I've considered all of those, the government has considered those aggravating factors, and here's why 14 months is still appropriate. If the government ignores all those aggravating factors and just says 14 months, it is not persuasive to the court. So that is not a breach of the government's agreement, nor is it a breach of the government's agreement to say that probation had the right to make a recommendation. In fact, the defense attorney also said that probation had the right to make a recommendation. So the government never violated its agreement, and also by telling the court that they could go higher, the court itself knew that, and in fact told the defendant in the colloquy, you understand that I can go higher, and you cannot back out of your admissions once I go higher. So that's not what caused the court to go higher. The court certainly knew that. The district court did not err in deciding to sentence the defendant to 24 months for his violations of supervised release. First, the court did not violate 32.1 at sentencing regarding the notice of the police reports. As the court recognized, this issue was waived by the defendant. The district court listed all of the documents and evidence that it had at the beginning of the hearing, and then asked affirmatively if the defense needed more time. The defense said that the defendant conferred with his counsel, and then they came back and said that they did not want more time. And all through the hearing, the district court invited the defendant to take more time at different points of the hearing, and the defendant insisted that he wanted to proceed that day. And even in his colloquy, he talked about why he was in a hurry to get this done.
That would go to the notice issue.
Yes.
What about the court's reference to the police report that involved a violation that the defendant had not admitted to, and the reference to the bathroom scuffle, I'll call it, between the defendant and a police officer where both got hurt? Why isn't that problematic, given that the defendant didn't admit to that violation?
Because, Your Honor, the district court had the right to consider the police report as reliable hearsay at sentencing, and found that police report was reliable. Let me back up. The prosecutor and defense counsel agreed, both told the court that they could not prove, that the court could not use unproven conduct. And in fact, the defense counsel started that discussion with a reference to the underlying thefts, the state charges. The court never found that the defendant had committed theft. The grade B violations, the court never found the grade B violations, and you'll see, I believe it's page 28 of the transcript, where the court said, I cannot make any findings as to those violations because the government has chosen not to prove them. Then when we got to sentencing, the court did, and on page 28, the court did also note, however, that's different than what I can consider at sentencing. And then at sentencing, when we got to sentencing, the court considered the police report as reliable hearsay. This court has found that police reports can be reliable. The court used it not for the underlying burglary or theft, but for that narrow example of how the defendant presents danger to himself, to law enforcement, and to the public. And the court found that it was reliable. It was not unreasonable to find that that was a reliable report. That report was a first-hand account of what the officers witnessed of the injury. They were on the scene, as opposed to, for instance, maybe someone else telling them, reporting the thefts that they weren't on the scene for. Those were detailed accounts. And the defendant corroborated those facts by his spontaneous outburst that he was the one hurt in that incident because he fell down and had to go to the hospital. So he didn't say that didn't happen. So under those circumstances, it was certainly reasonable for the court's narrow reliance on the police report as an example of how the defendant presents a danger to the community. As far as I heard the appellant raise the issue of the cross-examination of the police officers, certainly the defense counsel could have asked for time and subpoenaed the police officers or asked for the government and probation to work to bring them in. The defense decided to forego that. Lastly, the court properly applied the section 3553A factors. Esteros does prohibit a court from applying the punitive factors of section 3553A2A. But the court and the government acknowledges, in a case like this, Esteros says that where there's no objection, the review is for plain error. The government acknowledges that the Seventh Circuit has at times suggested that its precedent does not require an objection. But under any standard, the court does not need to decide this issue because the district court repeatedly relied on section 3553A2C, the need to protect the public, and also on the deterrence factor of 3553A2B. The court also mentioned her concern of under 3553A2D that the defendant had been out of touch for 15 months, and she was concerned about about the fact that the defendant had obviously not gotten any correctional treatment. But the court approached the sentence from the concern of public safety, which is permissible under Esteros. The court talked about the defendant's long history of, I believe it was 20 theft-related convictions and 17 theft-related arrests. And the court talked about how that was a pattern that she was seeing. The court wasn't talking about the underlying conviction in the Western District of Pennsylvania, which was conspiracy to transport stolen goods. The court was talking about the overall record and talked about how it started when the defendant was 18 and it went well into the defendant's 30s. And that this is the kind of pattern that creates a danger to the public, and that the West Chicago police incident was just an example of the danger to the public. The court never cited any punitive factors under section 3553A2A. The court never talked about the seriousness of the 2021 conviction. The court never talked about the need to promote respect for the law or the need to provide just punishment. If you have no further questions, then for the reasons stated, the government requests that this court affirm the revocation of supervised release and the sentence imposed by the district court with a limited remand to consider the application of special condition number 13 of the supervised release conditions.
Thank you, Ms. Mecklenburg.
Thank you.
Mr. Hillis.
To begin, it's not the defense burden to subpoena government witnesses who can come in and talk about police reports that they authored. The government has its burden, and it should have brought in the officers if it was going to rely on the reports. It didn't. Police reports are not per se reliable. Jordan says this, cites Downey versus Clincar. That's a long-standing principle. The court here made no findings about why the reports were reliable. It presumed that they were. That's a mistake. The officer's unavailability was never demonstrated in the district court. And as far as detailed police reports go, they are not in a special category, because Jordan says detailed police reports didn't save the day in that case either. So details, corroboration, things like that are all things to be considered, but they weren't enough in Jordan. They're not enough here. Jordan, of course, resulted in a remand. And lastly, the government's recitation about the history of my client's conduct in the past and how it warrants the sentence in the view of the judge sounds very much to my ears, the judge talking about the seriousness of the conduct in the past to justify the 24-month sentence presently. With that, I would just add that we have never contested the revocation, and furthermore, that waiver, to the extent that there's any waiver here, must be construed liberally in favor of the defense. And so my client was waiving the right to contest any grade C violations when he admitted to them. He had never waived the right to have the protections for any grade B violations, and so that's an important thing to note here. With that, thank you very much.
Thank you, Mr. Hillis. The court will take the case under advisement. The next case up for oral argument this morning is Archaldiacono versus Whitehorn.
I'd like to thank the court for the accommodation.
Of course. Good morning, Ms. Morrison.
morning.
Take your time. Just let us know when you're ready, please.
So my illness can manifest in coughing or gagging, and if it does, I apologize in
It's okay.
advance.
Take your time.
May it please the court, my name is Janice Morrison, and I represent Salvatore Archaldiacono, William Brown, Susan Miller, and William Sarche in this matter. My clients are the most vulnerable of the population. They are people who needed and currently need round-the-clock medical care in residential skilled nursing facilities. They also happen to be destitute, which should make them eligible to have their skilled nursing facilities paid for under Medicaid. So I'll get right into our constitutional claim. Under Goldberg, Medicaid is a property right which is entitled to due process because the potential for the plaintiffs to be condemned to suffer grievous loss. I can't imagine any plaintiffs that have ever been before this court with more grievous peril of losing human dignity and their well-being than the patients in this matter. Those are the circumstances that change entitlement into a property right. This law has been law for 55 years. The question here is whether the defendants have inserted an unvetted rule that is being used arbitrarily and capriciously to deny these patients their Medicaid eligibility without due process. So let's look at that process. The defendants would have this court believe that Medipac's complained of is merely a billing tool, a way for the facilities to bill defendants. The way the Medipac is used in practice, in name, and in result is actually a denial of the patient's eligibility. In defendant's brief, page 37, footnote 4, defendant cites cause of action versus Chicago Transit Authority, which is a Seventh Circuit case, saying that this court can take judicial notice of information on government websites. So this Sunday, October 26th, 2025, I downloaded from hfs.illinois.gov form HFS 1156, the form complained of in the complaint. And let me read directly from the form where it states on the form itself what its purpose is. The HFS 1156 is used by the LTC or the SLF facility to notify the Department of Human Services, Family Community Resource Center of admission, discharge, death, or other changes in circumstances of a client which could have an effect on continuing eligibility. Also on the same website, it is the code cited by the defendants in their brief, the Illinois Admin Code 89, Section 140.513. It states that the now named MEDI system was formerly known as Recipient Eligibility Verification. The defendants can rename it or state it functions as a billing program, but the fact remains it is what it actually does. It functions to arbitrarily and capriciously deny otherwise fully eligible patients from being denied eligible coverage. So the constitutional question is really easy. Does this impediment to coverage function as denial of Medicaid eligibility or continuing eligibility? Yes, it does. It says so on the face of it.
Is there any evidence that your clients have been denied services or they've been told by Medicaid they're no longer eligible?
Well, the purpose of the form
Putting the
stated
form
on
aside, I'm talking very specifically about your clients. Is there any evidence that they've either been denied the services or they've been told by Medicaid you're no longer eligible?
They have not been denied services. It is the defendant's responsibility, the defendant, to provide the services, right? But the state is not in the business of caring for patients. These are private facilities. The state of Illinois, if they had a state of Illinois skilled nursing facility where they paid the doctors, the nurses, the janitors, the administrators, all the attendant expenses, and they just accepted Medicaid patients, then indeed they would be providing the care. They're not in the business of providing the care. What they're supposed to provide is the money. That's what they bring.
So your harm you've alleged is that they may not get the services or they may not be eligible for Medicaid.
We're saying that this is a de facto denial of eligibility or change in eligibility.
So is there any evidence that your clients have been told by Medicaid that they're no longer eligible, that they may not be eligible?
Medicaid told the skilled nursing facilities and skilled nursing facilities in turn billed the patients, so they are at risk of losing money.
You say Medicaid told the skilled nursing facilities. What did they tell the skilled nursing facilities? That they weren't eligible? I thought they told the nursing facilities you didn't get the paperwork in on time.
They have a variety of different notices. Some say that the name is spelled wrong. Some say you didn't get the paperwork in time when the paperwork was submitted on the first day that the patient was in the skilled nursing facility, or they do not give notice at all sometimes. It's a very random and capricious, the way that the regulation has been put in is has caused chaos in an otherwise very regulated system of Medicaid and how that system is supposed to work under the state plan. We've alleged in our complaint that they did not get this regulation approved through CMS, which is required for any sort of change in the plan or any sort of change that would affect a patient's eligibility, which on the face of this form says exactly what it does, and how it functions within the system is exactly what it does. And in turn, as I said, those patients are being billed. Skilled nursing homes are allowed to bill patients who are not eligible for Medicaid or otherwise have insurance. By denying the eligibility through these Medicaid packs, they're putting these patients in the exact same standing as patients who have no coverage or who have flat out been denied.
But there's no legal obligation to pay. The billing notice is ineffectual.
That's a legal conclusion. The eligibility.
Well, that's not a legal conclusion. That's just the law.
Actually,
the law prohibits.
The law states that you can't bill. Bill a person eligible for Medicaid assistance from the department. this is effectively changing their eligibility.
No,
That's
it's
the
not,
argument
it's not
in the
eligible.
complaint.
It's not an eligibility determination. There's no question, and I thought the allegations, and this is a motion to dismiss, the allegations are that these 4 plaintiffs have been determined to be eligible for Medicaid. This is a question about the admission to a particular facility in each of these 4 cases, and whether that facility completed the paperwork in a timely and effective way to be reimbursed for the care that the facilities are providing for the eligible plaintiffs. The eligibility determination is not made at the facility level. It's made by the feds and the state together, and those determinations have already been made. It's a question of whether this facility can get reimbursed.
That's the
And to that point, I have a question about standing, because if there's an injury here, it's to the facilities for their inability to recover reimbursement for the care that they were providing to these 4 plaintiffs. And there's no claim for damages in this case. That has been disclaimed formally. This is a claim for injunctive relief only. And 2 of the plaintiffs had temporary stays in long-term care facilities in which the paperwork was messed up. And the other 2 have been readmitted to other facilities successfully and have no nobody has a forward-looking injury. Nobody has a risk of a Medicare, a packet, an admissions packet being mishandled by the state for a future admission. I don't know that there are any allegations that they are likely to be at risk of that happening.
That is the entire crux of the case, is that CMS, which is the federal program that is the agency connected with Medicaid, the ABE, the application for benefits enrollment, these patients are approved under the ABE. However, the crux of the complaint is that this particular form is acting as an impediment to eligibility. It states that it's a judgment of eligibility right on the form. It is acting as an impediment to eligibility, in which case if they are ineligible to receive these services, the nursing home has a right to bill them under Illinois Admin Code 140.12. There is damages beyond just being billed, because what's happening when you have a skilled nursing facility that's providing very skilled, very expensive care to patients and not receiving reimbursement because they've been declared uneligible, you have a lower health care bar. So in the case of my 4 plaintiffs, it was the amount of $111,373 that would have been given to these skilled nursing facilities. In turn, they can't hire the staff that takes care of these people. So if there's
Ms. Morrison, your
one-
time is up. I think you've answered Judge Sykes' question, so thank you. Ms. Jonick? Good morning.
Good morning. May it please the court. Assistant Attorney General Lee Jonig for the defendants. This court should affirm the district court's dismissal of the complaint, both because the plaintiffs lack standing and because they failed to state a claim. To start with the issue of standing, the relief that the plaintiffs are seeking here is forward-looking relief. They're seeking an injunction to require the state to change its processes. The injury that they claim are that they have received bills that have stopped accumulating. And so that's an entirely retrospective injury the injunction that they're seeking, changing this kind of going forward process, would not remedy these injuries. And so for that reason alone,
What about Ms. Morrison's argument that the injury is the impediment to eligibility?
I'm not
Ms.
sure.
Morrison just argued that because these forms are getting rejected and given the language on the form, that her clients now have an impediment to being eligible for Medicaid in the first place.
There's no allegations like that in the complaint, Your Honor. I'm certainly, they haven't made any arguments to that effect. The only argument that they've made that sort of addresses this issue is that this injury could recur again because they might get readmitted to facilities. But again, that's also not alleged in the complaint. And so for that reason, just based on the allegations of the complaint we have here, they don't have standing because they haven't alleged redressability. But even if they did have standing, the plaintiffs failed to state a claim both for a violation of due process and for a violation of the Medicaid Act. And with respect to both of these claims, the plaintiffs' arguments are really stemming from a misconception or a conflation of two different processes that go on within the state. One is the process in which a person applies for Medicaid benefits and long-term care benefits, and that's a process between the resident and the state. And the state approves them, they're approved. They do have to kind of resubmit to get reapproved periodically, and then there's a separate process between the facilities and the state, where the facility sort of agrees to participate in Medicaid, they get approved for Medicaid. So what these packets are all pertain to is the facility's submission for payment from the state. And so if there's some sort of problem, some sort of dispute between the facility and the state about whether something was submitted on time, whether something can be reimbursed, that's between the facility and the state. And the facilities agree when they participate in Medicaid not to bill residents who are eligible for Medicaid, as these plaintiffs are.
So as a legal matter, this has nothing to do with eligibility.
Correct.
This has everything to do with reimbursement.
Yes.
And so the injured party is the facility, not these plaintiffs.
That is correct. And to the extent that the residents are receiving bills, that's a legal wrong by the facility. And so, their whole allegation about, a property interest that they've been deprived of, is kind of based on this concept that they can, assert the rights of the facility here, which there's no authority supporting that. They have not been deprived of a property right. And then specifically with respect to the Medicaid Act, they assert two claims under the Medicaid Act. As we addressed in our brief, one of those claims does not state a private right of action. That's the reasonable promptness claim. They have not really addressed that in their reply brief, so unless the court has any questions on that particular issue, we'll stand on our brief.
That's a merits argument?
Yes. And then with respect to the, kind of setting that issue aside, the plaintiffs don't state a claim for either statute of the Medicaid Act that they've asserted here because, again, they've all received the medical care that they are entitled to. There's no allegation that they were ever in danger of not receiving care, and so therefore the state has met its obligations under the Medicaid Act. And unless the court has any further questions on that point, I just want to briefly address this argument that the federal government has not approved the state's system for submitting these admission packets. To start, there's no factual allegations supporting that system is in fact a material change to the state's plan. But even if there was, and we were accepting that conclusion as true, it wouldn't affect the plaintiffs' claims here because that wouldn't affect their property rights, and it wouldn't affect whether they received medical assistance with reasonable promptness under the Medicaid Act. So unless the court, happy to answer any further questions that the court has, and otherwise we'd ask the court to affirm the district court's judgment.
Thank you, Ms. Jonick.
addressed it.
Ms. Morrison, well, you used all your time, but if do you have anything further, we could give you 1 minute for rebuttal, or do you want to rest on your argument?
I do just want to rebut a little bit on the due process claim.
Okay, we'll give you 1 minute for rebuttal.
If the form that they're filling out is a judgment on eligibility the way it says it is and the way it functions within the system, then they are being denied due process, because under Goldberg, when Medicaid or welfare is necessary to life and limb, it becomes a property right. If this form is denying my patients their property rights to have those bills paid on their behalf, they are suffering from a deprivation of property without due process. And all it would require is that if the state was going to deny eligibility based on those forms, that they tick a box and notice and appeal rights go to the person whose eligibility is being denied. So that would be a $3 fix to $1 million problem. And having due process rights is the floor. It's if you're going to deny eligibility and not pay, they're private institutions.
Okay,
So
thank you, Ms.
that's their
Morrison.
volunteering,
Thank you.
basically.
Thanks to both sides. We will take the case under advisement. Our final case for oral argument this morning is case number 25-1316, Strong versus Dillon. Good morning, Mr. Lamar.
Hey, good morning, Your Honor. May it please the court. My name is Biavi Lamar, and I represent Josiah Strong, the appellant in this case. Josiah Strong respectfully asks this court to reverse the district's decision for 2 reasons. First, the district court failed to apply the federal accrual rule. And second, even if the court believed the accrual began earlier, equitable tolling and discovery applies and operates to save this claim. Your Honor, this appeal turns on a single, narrow question. When did Josiah Strong's Title IX claim accrue? In order to determine that a claim is expired, we must first pinpoint when it began. The district court nor—
Mr. Lamar, before you go too far down there, and based on what your introductory comments, I think you agree that this is a federal accrual. The district court said state. It was argued below that it's a state rule, but it sounds like you now agree this is a federal.
Yes, Your Honor, we agree that the federal accrual doctrine does apply. The district court nor the defendants have pinpointed a specific date under when that would have occurred. They vaguely allege it began sometime in 2015 or 2016 when Josiah was 14 and believed he was in a consensual romantic relationship with his teacher, and he now understands that he had been abused sexually over 20 times.
At that time, she wasn't his teacher, though, correct? She was his supervisor in an employment context, correct?
That is correct, Your Honor.
Does that impact anything in terms of the analysis?
No, it doesn't. It does not, because under the Title IX, he was a student. He was a person that was in a school setting, so we believe the Title IX still applies in that setting. Title IX does not arise from the sexual acts themselves, but instead it arises from the school's deliberate indifference and inaction to known sexual harassment. Josiah did not even realize that he had been abused until 2023, after years of therapy helped him understand that what he experienced was exploitation. He then learned in 2024 that the school had been warned and they had received notice in a secret meeting in 2015 and chose to do nothing. To my first point, the district court applied the wrong accrual rule. The district court failed to apply the correct federal accrual rule, and that was error. Accrual of a Title IX claim is governed by federal common law, not state doctrine.
Are you arguing that the court got the test for it wrong or applied the correct test incorrectly? Because I know the court said it was a state accrual rule, but I think it cited and was relying on what the federal accrual rule is.
Well, Your Honor, we believe that the federal accrual rule is what is to be utilized, and that in this instance, the court incorrectly cited to a federal accrual rule in CS versus Madison that I will go into that was not consistent with the precedent of this court. And to my point, the only thing that we borrow from the state doctrine is the statute of limitations, not the doctrine itself. This court has long held and stated explicitly that federal law determines when a 1983 claim accrues, but the statute of limitations is borrowed from state law. That was in the Manabera Equity Court versus Village of Oak Lawn. That was back in 2018. In addition to misinterpreting the proper Title IX federal accrual rule, the district court erred in 4 major ways. Number 1, they conflated knowledge of the sexual conduct with knowledge of abuse. Josiah readily admits that he had sexual conduct with his teacher over 20 times and about 5 or 6 times even after the school had noticed. But the difference between admitting that you had sexual conduct and knowing that you were abused is completely 2 different things, especially with a 14-year-old minor. Number 2, the district court ignored that institutional liability principles apply. This case is not about Dillard, who was the alleged perpetrator in this matter. The defendant here is the school. Institutional liability governs the deliberate indifference that we are alleging, the sexual discrimination, and the inaction that the school had. So even if he has knowledge that he has been sexually involved with the perpetrator, that has nothing to do with the evaluation as we look at institutional liability. Number 3, the district court improperly imputed the mother's undisclosed knowledge to the minor. We alleged in our complaint that in December of 2015, there was a secret meeting. Josiah, who is the only plaintiff, was not present for that meeting. His mother was, along with another parent who witnessed the inappropriate sexual conduct. In response to that, the mother never communicated this information that there was a meeting to her 14-year-old son. There's no factual basis at all to determine that Josiah ever had knowledge that the school had noticed and that they failed to act on this. The district court erroneously concluded that simply because a third party had noticed, that somehow that imputes to the plaintiff in this case. So we believe that was an error. Now going to the precedent that the district court utilized in this case, turning to its reliance on CS versus Madison Metropolitan School District. The district court alleged that the federal accrual doctrine begins when a school has notice of misconduct. Well, if we turn to CS versus Madison Metropolitan School District, it nowhere states that. The word accrue or statute of limitations is not even found in that case. That is not a statute of limitations case. It does not speak to when a Title IX claim accrues. The cited language addresses when a school's duty to respond arises, not when a plaintiff making claims of institutional liability standards becomes time barred. So that case was just completely inappropriate. Next, no Seventh Circuit precedent holds that limitations run from the moment that the school receives notice of misconduct. That has never been a standard that this court has ever stated. In fact, just 1 year ago, in SEOC versus Nicolet Union High School District, in August of last year, this court referenced the Supreme Court decision in McDonough versus Smith, 588 U.S. 109, where it articulated that while state law supplies the statute of limitations, federal law governs the accrual of 1983 and 1985 claims. This court went on to explain that in such claims, accrue when a plaintiff knows the fact and the cause of an injury. That is explicitly what was alleged in this case. We allege that on March 30th, 2023, Josiah, through counseling and therapy, learned of his injury, and then on page 8 of our complaint, on May 14th, 2024, he learned one of the factors that caused that injury, which was the institution's deliberate indifference and inaction to the notice that they had of this teacher's conduct.
Mr. Lamar, you are into your rebuttal time. If you want to save it, if you want to keep going, go ahead, but if you want to save it.
I will save it. Thank you,
Okay.
Your Honor.
Mr. Welder, good morning.
Good morning, Your Honors. May it please the Court. Peter Waldeck here on behalf of Appellee, St. Peter Emmanuel Lutheran Church and School. We are asking that the Court affirm the dismissal of this claim. When we get down to it, whether we're talking about accrual or the discovery rule, I'm not sure that that distinction matters.
It does matter which law we apply, federal or state.
I would.
So why don't you just take us through the decision tree, because the one that the district court used was not exactly right.
Well, they cited to C.S. Madison talking about accrual. And the court said the accrual begins when the school has knowledge and then fails to act.
That's what the CS case said, or that's what the district court here said CS says? Okay, let's just set aside what the district court said. This is de novo review. We can completely ignore what the district court said, and let's do that here. Start from the beginning. What's the applicable statute of limitations? What is the applicable accrual rule? What is the applicable discovery rule? And what are the applicable tolling rules?
Okay.
That's your decision tree. Go.
Thank you, Your Honor. The applicable statute of limitations is Wisconsin Statute 839.53.
Because this predates the change in Wisconsin law.
Correct.
And that statute, in fact, is not the omnibus personal injury statute, even back in the day when this court started using it as the omnibus personal injury statute. It's the catch-all statute, is it not?
It is.
Right. So there's a question about whether we've been misapplying that statute of limitations since the 1970s, but I fought that battle and lost, so let's move on. Okay? We're going to keep sticking with that because this predates the change.
Okay.
Okay, step 2.
Step 2, I believe you are asking.
Accrual rule.
Accrual rule.
Federal or state?
Well, the way it looks, it's the federal accrual rule.
And what is that?
Well, this gets to my original point of, I think it accrues when the plaintiff knows, or with reasonable diligence should know, which I probably inartfully stated it early because the rules do matter.
Right, and the CS case speaks to that or doesn't speak to that?
Well, it doesn't speak, I would agree, I don't know that they talk about accrual.
Wrong case.
But
Wrong
it does
case.
talk
there are
about.
Other cases say what you just said.
And this case, and the C.S. Madison case does in fact state that the claim begins to run when the plaintiff knew or should have known.
Okay. And if I could interject.
Yes, Your Honor.
Knew or should have known what for a Title IX case?
Well, that's a very good point. So the underlying act here is obviously the sexual act. The Title IX claim is going to be the indifference or the failure of the school to act on that. Now, it's hard to separate these two in this case because they're both kind of working together at the same time. But let's just deal with the action or the inaction of the school. What we know from the complaint and the amended complaint is we know that the plaintiff knew the identity of Miss Dillard. We knew that she was an employee. We knew she was an employee of our school. We know that she was inappropriately allowing him to drive her car, give him gifts, have sexual interactions with him. He, in fact, bragged about that, this relationship. This is in the pleadings, in the complaint. We know that the dad came to him when he found text messages, and he confessed. We know that Ms. Dillett came to the house and pled, please don't tell anybody. And of course, rightfully so, they did.
And this was before the 2015 explosion that surfaced this relationship at the school.
Correct.
Okay.
This is all, and it's all, I'm taking this all from the pleadings, obviously. He knew that Ms. Dillett was arrested, found guilty, and served 2 years.
And when did that happen?
That happened in,
And is this in the complaint?
it's in the complaint, amended complaint, paragraphs 46 and 47, original complaint 45 and 46. I believe all this was in early 2016 when Child Protective Services were called the investigation. So all this was there. Now, you can take
So
it-
he's being treated as a crime victim effective in early 2016 or 2015?
Correct.
Thereabouts.
Thereabouts.
Okay.
And so
And he doesn't file until 2024.
he doesn't. And it's understandable. I mean, take away the fact that he's a
Okay,
kid.
let's then maybe skip to tolling,
Well,
since we've established the likely accrual date when
Fair
he's
enough.
being treated as a crime victim.
fair enough. Number one, I'd be remiss if I didn't mention that I believe these arguments are waived, but that's boring and self-evident, so I won't go into it. With the tolling, if we look at whether they're talking about equitable tolling or equitable estoppel, it matters. But with equitable tolling, you need to have the Hester factors here, which they don't have. There's the 6 Hester factors, none of which apply here. And in essence, the sum total is my client would have had to actively try to commit a fraud or otherwise dissuade him from pursuing a claim or believing he didn't have a claim.
And those Hester factors that's a state law doctrine.
Correct.
Okay. And the case that says we apply state law tolling rules is what?
I've done my best to answer your questions. I'm at a loss here.
Yeah, I know I'm reconstructing the decision tree here, but there is a case that says we apply this Wisconsin tolling rules?
I believe there is. I'm looking through the equitable cases under the federal case, and again,
In the Title IX context, or is it borrowed from some other context?
I apologize, Your Honor. I just don't know if they're Title IX cases in the notes I have here, but we have the cases that are in front of you, and I guess I wasn't prepared to answer your decision tree at this point, so I apologize. But in any event, whether it's equitable tolling or equitable estoppel, regardless, my client would have had to actively have done something to prevent that. The other line of cases we see is this one of mutual mistake or nobody could have known. We look at the cases where an individual was in a coma. We look at the cases where the woman with the furnace went to multiple doctors and said, hey, I think it's my furnace. And they said, no, it couldn't have been. And that's where the court says, that's at least a fact question, is if whether or not you were diligent in pursuing your claim. So what we have here is simply the plaintiff's inability or decision not to ask the questions, whether or not he knew of my client's inaction or indifference to the abuse. It was known, and likely known by him, but if it wasn't known, it becomes an objective test when the facts and the reasonable inferences are undisputed. And these facts were taken from their complaint. All he needed to do was ask the question. He could have asked his mom, did the school do anything? He could have asked the school. He could have looked at the court records. He could have gone to an attorney. He could have done any number of things. The facts were there to be known.
What about the statutory tolling for his minority?
Well, it would then go to the age of majority plus 2 years.
And when did he turn 18?
He would have turned 18 in 2019, putting sometime in 2021 when they needed to bring the claim, which...
And it's whichever is longer, right?
Correct. And I did the math, and I'm not great at math, but any way you parse this out, 6-year statute of limitations, 3-year statute...
It's sometime in 2021.
Correct.
Basically, which is why a specific date is not pinpointed anywhere.
Correct. It's untimely under any of the analysis. And so obviously this is the argument. We would then have indefinite statute of limitations always if people could just be willfully ignorant of the claim, not ask questions, and just say, I don't know. We're not dealing.
Wouldn't the question on accrual be for the Title IX, though, that when your client knew or reasonably should have known that, when the plaintiff knew or reasonably should have known that your client was on notice of the misconduct and didn't do anything about it while it was ongoing?
Mm-hmm.
So wouldn't your client have to know that, or should have known, have reason to know that during the course of the conduct, it was ongoing and they didn't do anything about it?
Correct.
So if he found out about it after the effect, once she was arrested, the school clearly knew about the misconduct, but there's that second piece for deliberate indifference that he had to have reason to know that they knew about it before then and did nothing.
Yeah, and the mom was in the meeting and knew and requested the formal investigation.
And that's the question about imputing the knowledge to
But it's
him.
it's not imputed, because I'm not asking the court to impute that knowledge. What I'm saying is reasonable diligence. All he needed to do was ask the question.
Isn't that a issue for discovery, though? Because we're on a B6, and we rarely decide limitations disputes on a motion to dismiss. And I'm looking at paragraph 43. Josiah had no knowledge of the initial reports of Dillett's improper conduct, and it goes on. You know, there are reasons why the mom might not have shared the meeting. Maybe she was embarrassed. Maybe there was shame. Maybe there was a taboo about sex. So perhaps the mom didn't share it. And it wasn't until the dad, busted him on his cell phone that it all came out. But at this procedural juncture, I mean, I could see a lot of depositions of the mom, of Josiah. Is this really reasonable? Because I see that the district court here actually did kind of conflate the mom and Josiah. And at points in the opinion, he talks about they. Well, mom is not in this case. We're talking about Josiah alone and what he knew, and we must take these allegations as true, correct?
I'm assuming the mom didn't share this information. Yeah. Reasonable diligence. All he needed to do was inquire. It was knowable and easily knowable.
But what would he have inquired about if he didn't know that the mom was meeting with the school?
He would have asked. He knew she was an employee of the school. He knew that was the employer. He knew the relationship there. All he needed to do was inquire to see, did the school do anything? Otherwise, we can all walk around willfully ignorant and say, I didn't know you manufactured the product that injured me until 20 years later when I was reading a magazine and I realized, and that's when I decided to sue you. I didn't know your farm was the one that didn't wash the vegetables I ate. I sat around and had terrible liver failure and went to the hospital and never asked a question until 50 years later.
Counsel, I get your point. I get your point. My point is a procedural point about Mr. Strong very well may lose at summary judgment, right? Once it comes out. But he was 14, 15, and you're saying he should have asked.
By the time he reached the age of majority, he had 2 years to ask questions, and he chose not to. We don't live in the world of Socrates or Nietzsche where all facts are relatives or we know nothing. We live in a world where we have facts and the law applies to them. These were knowable facts, readily ascertainable by him. All he needed to do was ask the question. They were there. It wasn't some esoteric discovery that he needed to conduct. It was self-evident. He knew the school. He knew the employer, he knew the employee, he knew what happened. All he needed to do was ask.
You could ask that at a deposition, can't you?
I could ask it, or I could ask your honors to say that it now becomes an objective test because it's a reasonable inference under the law. It would be unreasonable to say he shouldn't have asked those questions if he wants to maintain a cause of action. He's given the age of majority plus 2 years. The legislature has found that that's sufficient time and failed to act within that time period. Otherwise, we invite an open door to people claiming I just didn't know and I didn't ask any questions. They're not coming here
But
saying
in the
we
Title
asked
IX
questions.
context, counsel brought up a case, CELAC, which is a 1983 case. Are you familiar with this case?
I'm not.
Okay. You ought to read it because it's a 1983 case, and in that case, we tied accrual to both knowing the fact and the cause of an injury. And in that case, it was 1983 against a school board, the school's failure to take action and investigate. And in that case, one of the plaintiff lost on other grounds. It was a Manal claim, but the court found the plaintiff's claim timely under the accrual rule that essentially the plaintiff is asking for here.
Well, and that case may be dispositive. I don't know that it's in the briefing even, but I'm not familiar with it as I sit here. What I do know is that we have repressed memory cases, we have coma cases, we have somebody being knocked out cases, and the court in those situations can find, hey, there's a reason not to know. But when the facts are known or knowable and they do nothing to inquire, it is then unreasonable, and it's not a reasonable inference to say, well, they just didn't know, so the statute continues. At some point, the rubber needs to hit the road on this. He knew he was given till the age of majority in 2 years to simply ask the question and didn't do it.
Thank you, Mr. Waldeck.
Thank you.
Mr. Lamar, you have a few minutes left for rebuttal.
Thank you, Your Honor. I will quickly just go to the court's holding again on CS versus Madison. It appears that both sides agree that this is not the correct standard that was rendered in the district court's opinion. It is not a statute of limitations case. So again, just on that basis alone, we believe that that doctrine or that case was not relevant for this matter. We have cited a string, as the court has acknowledged, through just last year, Side versus Nicollet Union High School District. They have said this repeatedly. I mean, I can go through almost 20 plus years of doctrine of Seventh Circuit Court where they've always stated that claims accrue when a plaintiff knows the fact and the cause of his injury. It now appears that the defendants in this matter also agree. So now we turn to the fact basis. As the court, as we stated before, there's nothing in our complaint, and we must apply this based off of Iqbal, that we have alleged that he did not know anything until the filing of, until May, until 2023, and then also the cause of his injury into 2024. So that is what the court should assume. And again, we would expect that the defendants get to discovery and they contest those facts. There's no precedent whatsoever that imputes a third party's knowledge, his mother. I want to also go back to the complaint. They alleged that in our complaint that he knew that there was a criminal investigation. I mean, he knew that she was convicted. Our complaint doesn't state that. It states the facts that under paragraph 45, that Ms. Dillard pleaded guilty to 2 felony charges of sexual assault. It also, in the paragraph 46, acknowledges that she was sentenced to 2 years in prison and 3 years of extended supervision. There's nowhere that it imputes that knowledge to Josiah. Those are just facts that were alleged in this case. So again, with time, only a few seconds left, we would...
He's the victim of the crime. He certainly knew of the prosecution.
Yes. And
that's the only plausible inference from that.
Yes, Your Honor. He knows of a prosecution. He's 14 years old. That doesn't mean he even understands what a criminal justice system is, or that it was improper for an adult to even have sex with a 14-year-old. There's no evidence that shows that that was his knowledge or that he knew anything was wrong. He thought he was in a consensual, romantic relationship, and that is what this second amended complaint alleges. Thanks, Your Honor. And with that, we ask the court to reverse the district court's decision. Thank you.
Thank you, Mr. Lamar. Thanks to both sides. The court will take the case under advisement, and our oral arguments for today are done.